Mediation can be a powerful tool and one of the most important tools in your separation or divorce process, but only if you know how to prepare and if you come prepared. In this episode, we're going to be talking about the top 5 things mediators wish you knew before walking into the room or logging onto Zoom. Welcome, Mel. That last bit rhymed. So
It did.
we're really going to be talking about, I know people, they hear that they've got mediation and they freak out and they go, what do I do? What am I supposed to do? But really, I think today we're going to touch on those 5 things, and hopefully we can give you some clarity and take away some of that anxiety. And as I've said, it really is a very pivotal moment. It can be the difference, between settling or moving on to a scarier course.
Yes, absolutely. Very important.
Okay. All right. So let's get to our jingle and let's get started.
Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
So, the first thing that, Mum, you've said that mediators really wish people knew was that you don't have to be in the same room.
You don't have to be in the same room as your ex, okay? Sometimes mediators might want you to be in the early stages so they can talk to both of you. But if there's a reason why that would freak you out and you can't do it, just say no. And the mediator will give their opening statements to both of you separately. Okay, so separate rooms is the way to go. And if you're really nervous, separate arrival times and leaving times may also help you. Okay.
I've heard some people say they've asked for it and they didn't get it.
Wow. Okay. Look, if that's happening in court with the registrar of the court, you're probably stuck with that. But if you're using a private mediator, someone from Relationships Australia or whatever, when you do your intake, tell them you need separate rooms, otherwise, or that you need to be able to come by Zoom. Otherwise, you can't do the mediation, because the central practice direction and the court's overview of things is that you shouldn't do anything, shouldn't be made to do anything that makes you feel less safe. Okay.
Why is having separate rooms, obviously, apart from the obvious reasons of if you've been through an abusive relationship, the last thing you want to do is be sitting across the table from this person. But why can staying in separate rooms actually lead to a better outcome? What have you seen when you've been a mediator?
Well, you can tell in mediation if you have the both parties in the room, and sometimes their lawyers will go, oh, yes, they're fine, they can come in the same room. And then you observe the parties while you're talking, and you can see that just a look from someone who's been able to control another person, just one look at them and they lose their train of thought, and you're essentially putting them in the same room with each other, where ultimately, in order to settle, each of them has to give in a little bit. And that means you've got to say no to your abusive ex, and sitting in the same room with them and saying no is scary.
Can it help if it's not an abusive situation? Can separate rooms still help mediation if, say, it's just high conflict, or if it's avoidant or amicable?
Yeah, I think so, Laura. I think so. I used to think separate rooms years ago in the early 90s when I was mediating. I used to think that was a bit of a cop-out. And I used to feel, and I think that was the view of the mediators in general, that if you can't put the parties in the same room as each other, then there is an imbalance of power somewhere in there, and therefore it's not suitable for mediation. But we've moved a long way from that in the last 20 years. And now people are saying, well, it last 30 years. They're now saying, look, we can put you in separate rooms. We can put everything in place to make you feel safe, and that will work. If you just on a whim, or you just don't feel like having to see the other side. And don't forget, high conflict is also, if you're scared of another person who's high conflict, then there's probably more going on than just a powerful fighting thing. You know what I mean? So I think if you feel like you want a separate room, you can have it. I think it's good. You can take a friend. You should just tell the mediator you're going to bring a support person. You can spread your file out. You've got your calculators, and you can set up an office for yourself. And I'm talking not the lawyer, but also the individuals. And you can have a sandwich, And just that's your comfy space. And the mediator then gets to take the results to the other room, and they cop whatever it is initially, and then they bring it back in a kind of sanitized version to you.
Is it the same with Zoom, or do you have to be in the same room with them in Zoom?
No, you don't. Zoom, it's fraught, it was very fraught as we all got used to the technology. But no, you have separate rooms. Most mediators who are doing Zoom conferences now have a shared room, but the only people who go into that are usually the solicitors and the mediator, and if you've got one. And then they have an individual room for each of the mediating parties, and their lawyers hop in and out of that room as well. So they get very high tech.
Can I, just in case, and I know everyone who's listening to this, their heart's probably pounding, and we are going to give you some more other valuable tips, even if you're not going through an abusive relationship. But if you want to have a little giggle and you're doing a Zoom or a Microsoft Teams before you go on to just relax some of your tension. Back in the COVID days, there was a court appearance. I don't think it was a mediation, but it was a court via Zoom or something.
It was.
And the lawyer must have had kids and it had a cat filter. So when he appeared in front of the judge, as a lawyer, it had a cat filter on, and they couldn't figure out how to take the cat filter off. And he said, "I can assure you, Your Honour, I am not a cat." And I'm willing to proceed.
Yeah, I'm ready to go forward. And then I loved the comments were like, well, that's just what a cat who was pretending to be a lawyer would say.
But so
Yes.
just be mindful if you are going to be doing a Zoom or a
Mm.
Microsoft Teams, if you have used it with your children or you've done, make sure the background isn't space themed, or sometimes with mum, I use like an aquarium background. Just make sure it's all the filters are off. Make sure all the filters are off.
Yes.
All right, so mum, number 2 big thing mediators wish you knew if you're going to mediation is that if you want to settle, you're going to have to compromise. Now, we're
Yeah.
going to give you some tips on how to flesh this out. But mum, can you just explain the whole compromise separation?
So when you decide your position, when you work out what it is that you want out of property settlement or children's or whatever, you've done that looking at your point of view, and you've come up to a number or a days or whatever it is arrangement. Presumably you've communicated that to the other side before mediation, and obviously they haven't agreed. Otherwise you wouldn't have had to go to mediation. So you're starting off with a position that is unacceptable to the other party. So if you're going to get anywhere, you can't just send that proposal and they'll send their normal proposal back, and then you send your normal proposal back. It is going to be kind of an auction. It is going to be a little bit of bartering. And so ready yourself for that. Prepare yourself for that. Think of the things that if you had to, you could compromise on, okay? I always call it bringing a bit of Irish thinking into it and just looking at things a little bit differently. And one of the ways is to check and see what their interests really are. If it's cricket, well, maybe they could go to cricket and come home the afternoon, all that sort of stuff. So, yeah, that's the theory. And I do think if you go in with the view that if you have to, you can give a little, and the other person goes in having been prepared that they could give a little, your chances of a good result in mediation increase.
Right. So let's just quickly look at the personality types for this, making sure you have to compromise. If you're going in with a narcissistic type or manipulative, controlling, we have a really good episode called Can You Really Mediate with a Narcissist? And we have another one of, is it mediation or manipulation?
Yeah.
And what to do if they don't, if you know they have no intention of settling. There are strategies and things you can do so that that's not a waste of time. We're not talking about those today, but please go and listen to them. I'll put them in the show notes. But Mum, basically, people need to have very clear goals. Now, I'm just going to throw myself in the naughty bin because 1, I didn't really know what mediation was, ironically, properly. 2, I did no preparation. I didn't think about anything. I just assumed my lawyer and the mediator would just, I don't know, I just assumed it would somehow miraculously sort itself out. So I did not do the work and it didn't succeed. We didn't. And that partially may be a bit of, I should have spent some more time thinking about things. But if you have clear goals and then some flexibility, which is hard, but really, Mum, you could separate your must-haves from your nice-to-haves.
Yeah, I think that's right.
list
Yes.
must-haves and nice-to-haves. You don't have to tell them all your nice-to-haves.
No.
But at least you know you've got a list there.
You've got a little bit of wiggle room. And you are, in a way, those scales they always use to illustrate justice, the justice scales. You can put your nice-to-haves on one side and the cost of a court case on the other side, and see whether your nice-to-haves are really that important, and are you prepared to pay that much money and take those risks for it? So it's a balancing act. It's a look at your need to have, as you say, and nice to have, or needs and wants, and just looking objectively, and try not to get back into the resentful feeling towards the other person, because, and this is what happens, Laura, some people, they've had a long marriage where they've always given in to the other person and deferred to the other person, and separation may be the first time they're actually standing up for themselves. And then we're asking you, or your mediator are asking you to give in a little bit more, and it's like, no, I'm done. I've done that for you. Well, you may be just a little bit longer for the sake of settling it.
Which would be so hard. So if you don't do the mental prep work before you go in, you're really setting yourself up for failure, I guess. And we're not saying you do all the compromising and they do none of it, but you've got to be willing to do some of it, or like Mum said, you're just going to be sending each other your original proposals back and forth. So, all right, let's go on to number 3.
Okay.
And this is like pretty much super obvious, but for some reason there's a lot of dotes out there that don't do it deliberately, I think, most of the time. But that, be prepared and have your documents and disclosure ready.
Yes.
Like, what do mediators wish people knew that, Mum? What can you not do mediation without disclosure?
I think sometimes you can, but it depends what it is that's not being disclosed. But on the day, you need to know what the property pool is. So you might not have received, for instance, every bank statement for the last 12 months, but you don't think that's too bad as long as they bring a statement of the balance for the last 5 days or something like that. But yeah, have your documents ready. Make sure you've done the prep work at least, and have something to back it up. Like if you say the car's worth 20 grand, bring your red book value. Because I've seen something like that where you're prepared and you've got a document that can, the mediator takes that into the other room and suddenly they're agreeing and compromising. So even if they don't, you do yours, so that it doesn't hold it up, I guess.
So basically for property, anyway, you've got to go in yourself with an idea of what the property pool is. Yeah. Not a rough idea, like a pretty specific idea of what the property pool is, with valuations to back up your reasoning and receipts, basically, documented proof. And that's going to stop the high conflict people, isn't it?
It is. Sometimes it's not a receipt though, Laura. Sometimes it might be there's an old BAS statement that you happen to have, or there's been a sale of something and you know the price of what it was going to be, or you bought it not long ago and this is the money. So whatever evidence you can gather up and put that out there, that gives you a stronger position. What you're going to have then is not just your ex, but hopefully his lawyer will be there or her lawyer will be there. And the lawyer's going to go, oh, well, this changes everything. This document is the thing. And it is frustrating in mediation if the whole thing hinges on evidence of one thing and nobody's got that evidence. You reach a kind of airy-fairy arrangement, and then the valuation on the house or whatever it is comes in differently, and suddenly everyone's changed. Oh, no, I didn't know it was going to be that low. I'm not settling. So,
what about with children's matters? What kind of disclosure and documentation can you have to help argue custody arrangements?
Yeah. So that's a really sensitive area, isn't it, with family dispute resolution? Again, I think you'll never convince your ex, I don't think. And just like your ex probably will never convince you if you've got a position on the kids' matters. If yours is based on safety or theirs is based on safety and yours is based on rights, whatever. But it can sway both the mediator a little bit and your ex's lawyer. So if you've got things like evidence of the kindy that the kids have been going to or the school they've been going to for all these past years, you can have that there in black and white. So when what looks like an innocuous proposal to send the kids to this school becomes more of a serious proposal if you can prove evidence they've spent like 6 years at the other school, that sort of thing. It's hard. I mean, luckily we can carry a lot of it electronically, and there'll be printers in nearly every mediator's room, and we all carry our lives on our devices. So usually we can pull them up.
Doctor stuff and psychologist stuff? Kind of important to take?
It is. I mean, if you're doing mediation under Section 60 of the Family Law Act for family dispute resolution for kids, you haven't got the benefit of subpoenas and stuff like that. So you've got your words for things, I guess, and maybe make yourself a list as the reasons why you can't agree to this other thing, and try and think again of some ways that you might be able to compromise a little bit without compromising anyone's safety.
And look, I think you might be right there about making lists. And sometimes I think people think, oh, well, it's mediation, it's not court, it's going to be easy. But in some ways, I feel like it's harder. Whilst court forces you to make documentations, write affidavits and do all that sort of stuff, mediation can feel like a little less hard. But if you take the time to sit down and, like you said, Mum, list out the reasons why you want the specific custody arrangements or the specific parental responsibilities or whatever, because I can tell you personally, when you're in there and if they upset you by saying something outrageous, or if you're just completely frazzled and stressed because you're looking at the clock going, we've only got 2 hours left and we haven't sorted anything, you're going to forget half of your points. They're going to fly out the door. And as much as I love the lawyers that I had, and as much as I love the lawyers that I know, some of them, that you can't rely on them to know all of those things, because they're your kids. It's your passion. It's your life. And to them, it's just another mediation. And to be fair, I think some lawyers just sit back and go, well, this is kind of up to you guys. I'll just be here as a personal assistant and type this stuff down. So you really, really need to be brainstorming and thinking about this stuff, which takes us on to the fourth thing that mediators wish people knew. And that is anticipating your ex's roadblocks. And you did touch on it before, Mum. What do you mean by anticipating your ex's roadblocks? And that's something else that you could probably sit down in advance.
Oh, absolutely. Absolutely. Sit down in advance and think about that. So you've got to list, like you said, and a list means you don't forget any points and their lawyer hears your whole argument. Just going back to that point, because you probably haven't been in court yet, so you don't have your affidavits or anything yet. You've just started, so you do need those lists.
So that's a valid point, Mum, because your ex's lawyer might not know the full story until they get an affidavit for court. But the other opportunity is to give that ex's lawyer the full story during mediation. Is that what you're saying? And then they put the screws on their own client to say, come on, this is not going to work out for you very well if this is what has happened.
Yeah, absolutely. Absolutely.
Okay. Anticipating your ex's roadblocks.
So when I learned mediation years ago, they used to teach us this, and it was a very powerful thing to do with a listener or a mediation person mediating. Why do you reckon your wife will not accept that? Oh, well, they don't agree with this and they'll never let me have it. Well, why would you put that proposal to them? It's not a genuine attempt to settle. What is it about that particular thing that is going to be their kind of point at which their roadblock, which they will not move around? How can we get an agreement that doesn't offend their roadblock, that removes that roadblock? And so that also is in your thinking phase earlier on, and ask yourself, why do they want something? And if you can't be clear, then try and think of what it is that they don't want. So if they're asking for days, a couple of days, one day Tuesday, one day on Friday, that means they don't want Wednesday, Thursday. Why is that? And then you can be more mindful, I guess, about what you propose.
So we do talk about this in the narcissistic, can you mediate with a narcissist? But this is something to consider, and that's something you brought forward, which was really resonated with a lot of people. For example, some of them just want to look good and they want to come out of the divorce saying, I look good, I'm a good parent, there's nothing wrong with me, look at me, I'm a good parent. And that may, to them, looking like a good parent may just be taking their kids to sport on the weekends.
Yes.
Not looking after them all the other times. But if you can kind of figure out what it is exactly that they think makes them think, oh, yes, I did good. And how can you work around it? They may be fighting for 50-50 custody. They may be fighting for full custody. But if all they want to do is just take the kids to sport, then work a way around to get them to take the kids to sport. I guess that's one example.
Yeah, I had an example where the other person was absolutely high conflict, and they kept insisting on Sundays every week for them to have the children. And my client kept saying no. And then it came out, it transpired that there were religious things that the one client did with the children, and the other person, not that they didn't agree with the religion, but they just wanted to thwart that, just to stop that. So once you call them on it and say, I know why you're doing that, and then that can sort of ease the roadblock down.
Right. And I guess it's also good to anticipate what your roadblocks might be.
Yes, absolutely.
And ways around them.
Yeah. And reality check yourself with those roadblocks, because I talked about the scale, and we talked then about the nice to haves and need to have and the cost. I think you need to haves could also go over those scales and have a look at the cost, because here's the thing. You may not just be paying your legal costs. If you stick to your guns on something, in spite of advice, like if you've been told by other lawyers that it's not achievable and you still stick with it, if you get to court and the judge agrees with those other lawyers and you don't get what you want, not only do you have to pay your legal fees, but you are most likely to have to pay some of the other parties' legal fees for being unreasonable. So it's a big risk. So really get to know yourself. Be careful who you talk to about it, right? Don't talk to someone who's angry with your ex or who has a vested interest in bringing your ex down to their knees. Try to talk to someone that will be objective for you.
All right. And that puts us to the last one, Mum.
Yep.
And we can then talk about all the different personality types. I think it's important for this one. But the last one is you're in the driver's seat. So court is different to mediation, and you have the power.
That's right.
You're invited to our free webinar. Whether you're stuck at the beginning of deciding to divorce or you're struggling to find your way through the legal jargon and fear of the unknown of the legal process, we are here to empower you to take control. Join us to learn what steps you can take, followed by a live Q&A where you get Lynn, my amazing mum, and family law accredited specialist to answer your questions. All you have to do is go to www.thedivorcecourse.com.au and click on Reserve My Seat. We'll see you there. Hurry, spaces are limited, so don't miss out. Register today.
Got that?
It doesn't feel like it, I think. So mostly you're sitting as a person going through mediation, and you'll understand this. Even if you have your own room, you sit down, right, and your lawyer and the mediator pop in and out. They go and talk to the other side, and they take ages and ages. And then when they come back, they feel like they only talk to you for a little time. Most mediators time it, but it's all in perspective. So you're sitting there. They come back in so many times, I've noticed that neither the mediator nor the lawyer will sit down again if they're coming to talk to you about instructions. And I think it just makes you feel small. And these people, they know everything because they've been in the other room or they've had discussions. And you're sitting there you feel like you're the kid, right, waiting for the bus and they're the bus driver. But the reality is it's mostly you. It's your work you've got to do. You've got the power to say no. Just remember that this is your show, okay? And they can advise. And the most common thing that I hear, Laura, is that people feel they were pressured or they were railroaded. And
they felt like they had to.
Yes.
Or they were told that if they didn't, that there'd be consequences.
And look, that's legal advice. It may have been right. It may not be right. As I said, they don't always know the whole story in those early days. The affidavits haven't been filed necessarily. So you can say at any time no to a proposal. You can control the proposal or offer that might go to the other side. The only thing that the court asks of you is that you make a genuine effort. It doesn't require you to settle at mediation. And every case that ever goes to trial didn't settle at mediation. And, you don't want to settle and then be kicking yourself forever. There's often pressure on you to sign on that very day where you have the thing. But what if it's 6, 7 o'clock at night, you haven't eaten properly, you didn't sleep properly last night, but couldn't keep breakfast down. And now they're wanting you to sign something that's you're stuck with for the rest of your children's childhood or for the rest of your life if it's finances. And it's okay to say, look, I want to think about this overnight. It's too late. And I think one of the things you can say that should give a red flag to them all is that I feel pressured. I can't think straight. I need to have a break and I'll talk to you about it in the morning. And then you can take that away. It's still allegedly on the table. The other side might say, if you don't accept it now, it's off. Fine. You can still take your agreement away. And if it's suitable for you and you can live with it, then you might be able to send it to the other side as an offer, as is an open offer, like something that will be raised in court in relation to costs. And if they say no to that, then everybody knows what you're dealing with on the other side. If it was their proposal and 12 hours later, it's not acceptable.
And I think it's so important for everyone to know that, like you said, Mum, there's a lot of pressure put on you to settle because mediators sometimes have like strike rates or success rates. And I've done 26 mediations and all of them settled. So there are outside factors that can be affecting and influencing your decision, but it doesn't affect them and their lives.
It doesn't.
So we do have a great episode called What Happens After Mediation, where Mum talks about mediation remorse, what you can do, can you undo it, what happens if the other side agrees and then changes their mind. So there's a lot, and what do you do with the documents, etc. Go and listen to that episode if you'd like to know what happens afterwards, or if that's you right now. But Mum, so basically we're giving you guys homework.
We have.
If you were a member and you do our call that you go and do with the mediation module, straight away, I would highly recommend you do that because we take you through all sorts of stuff. But basically the homework we're asking, if you've got a pen, write this down. Make a note to ask for separate rooms for shuttle mediation if that's what you feel will help you to when you do your intake. Make a note of your clear goals and remind yourself to be a little bit flexible. Have a list of your must-haves and your nice-to-haves. And then also have a list of how much it's going to cost you if you go to court. Find out. Go see the lawyer. Get them to give you a rough estimate of how much it's going to cost to go to court. And they have to do that anyway.
They do. They have to do it anyway. And even if you're representing yourself, you have to do it. So,
okay.
Yeah.
All right. Do those little bits.
Yes.
And then go and do your disclosure. Make sure you've got it all. And when it comes to children's disclosure, people just like, oh yeah, I don't really need that. But like Mum said, you can sway. If your ex is a lying little so-and-so, you can get their lawyer on your side by showing the proof.
Yes.
And then you've got an advocate for you in their lawyer. Now, 9 times out of 10, usually what those kind of people do, the manipulative controlling, is then they sack their lawyer and start the victim role again in a new legal place. But at least you can just keep using that to be like, actually, this is so have all your disclosure ready to go. Yes. If you need a disclosure checklist, we have a disclosure checklist available for free in our free resources section at www.thedivorcecourse.com.au. Go up the top on the heading that says free resources, click on that and you can download the free disclosure checklist. There's also a free mediation checklist as well.
Laura.
And then I want you to, Mum, still giving homework. The other thing I want you to do is write down a list of all the objections your ex is going to have with what you offer. And can you think of a way around it? Thinking about why are they objecting and what can you offer that's going to overcome that objection?
Do you know what, Laura? I call them the but. And you have to deal through those. And also, Laura, we're on YouTube now and we should, if you've enjoyed this or it's helped you, please subscribe because I just like to see subscribe or at least like the episode and help get this out to more people. No, seriously, because you have found us, but there may be someone struggling on their own who doesn't know about these. This is a free help.
So So, Mum, when it comes to, we're just going to quickly touch
Okay.
on the divorce personality types. If you've listened to our episodes before, we touch on these as amicable, avoidant, high conflict, and manipulative controlling. So when it comes to mediating and prepping, what would your mediator want you to know if you were mediating with an avoidant person who doesn't want to deal with the situation? Is there anything the mediator would want someone to know?
Yes, I think the mediator would like you to know if you've got an avoidant person, try and put the things in the easy agreements first before you get down to the stuck bits, because once they get momentum, then they may well be able to face the other stuff. A few kinder things. I think that would work.
Okay. Kind of thing. So
Well,
little mini agreements that you know they're probably going to say yes to, or stuff that you may have agreed to verbally.
Or stuff that they've let you know is absolutely vital. And like it might be, look, you tell the mediator, please, can you let them know I'm not going to go valuing their sewing machines and stuff. I have no intention of taking that part away from them. And that just, or I'm not taking their motorbike. I want them to keep that as part of the settlement.
Yeah. Okay, cool. That's a good tip. What would your mediator want you to know if you're up against an amicable?
I still think, look, honestly, they would like you in the same room, but I think you can be more honest with each other if you're in separate rooms, because amicable has its limits. If there's no argument whatsoever, then one of you isn't necessary. One of you is being cowed by the other person, and it's not actually amicable. It's manipulative and controlling personality in disguise as amicable. So in the separate rooms, it allows you to spread out your stuff. It allows you to speak candidly with the mediator, and it slows it down.
Because even if you are amicable, someone probably chose to leave.
Yes.
Usually. Sometimes it's a joint decision, but someone pulled the plug.
Yeah.
And there is an emotional pain that goes with it. I think a lot of people who want to be seen to do the right thing, to be amicable, and I know a lot of people do it, which is great.
Yes.
But there is that hurt there. And I think sometimes in a heated, it's not heated, but it's a high stakes negotiations for a whole day in one room with the person that's either cheated on you or said, I don't love you anymore, but I'm still going to be nice to you. That can really affect the way you make decisions. So you need that breathing space.
Yep.
I really think you need that breathing space.
I think so. And amicable people, usually, they're nice people. They don't want to be seen to be pushy about their own situation. And you may come into that category yourself. And if you know that if someone puts the pressure on you and you can see, you think of the other person's point of view and you think, well, maybe. So, yeah, no, you need it separately.
And this does go for any of the divorce personality types. If you're in the same room with your lawyer and they're in the same room with their lawyer, you'd have to leave the room to ask any questions to be like, is this actually going to be okay for me? If you're worried about looking bad again. So it is good to be able to have private discussions with your lawyer in a different room. Now, so
sometimes too in a single room, and I think this will come into high conflict as well, but sometimes it's hard for the mediator to keep control of everyone in the room and to stop the parties themselves bickering. So, yes, we don't want that.
Coming from 2 primary school teachers in the past, we know how hard that is when there's 2 kids fighting over whose Pokemon cards these were, or like that time I had some drama with a girl because we both had the same toes.
I remember that.
So it is hard. Yes. And I was a child at that time. I wasn't a teacher arguing over this. So then the other 2 personality types is high conflict, Mum.
Yeah.
So high conflict, they're fighting. What would a mediator want someone listening today to know if they're going into a mediation with a high conflict?
I think it's like, don't poke the bear unnecessarily. If you've escaped from a high conflict situation and you are beginning to get your own strength back, it's almost irresistible to have a shot back at them for the years that they've given you all that trouble. But no, if you make a proposal and you look at it and you go, that'll sort her out, no, take that out. So don't make it any harder than it already is. I think that's what we want to see. And I think it may be that your high conflict person absolutely can't bring themselves to make the first offer. Remembering your offer is lower than what you've been talking about, and it may be that you have to do it. And a mediator wishes sometimes that the person who is in high conflict would understand that sending the first offer over doesn't mean that you're giving in or that the other side has somehow won.
Right. I think you made a little point there that is important to note. Lawyers and mediators don't know the trigger words, or if you've had an ongoing 7-year fight over what color the sky is, or some little nickname that you used to call their mother-in-law, and they somehow sneak that into something, and the lawyer's unaware of it, the mediator's unaware of it, but it's a way to get at you, or vice versa. That stuff has to stop.
Right,
and if they do, you have to just do what Mum says when we do how to read a word salad letter like a lawyer. Just ignore those things and just focus on the facts, which is really hard to do, but you don't want to get knocked off the rails. You need to be on your A game in a mediation.
I remember one, it happens with writing letters too to the other side. I always get my clients to check them. But the other person on the other side hated being called a secretary. They were a personal assistant. And yes, and my lawyer would my client would put that word in. And in a chat with the other lawyer, I realised what was going on. How's that helpful? How's that helpful?
Yes.
And it's money.
So don't do that. Otherwise, it's a waste of your time and money being at a mediation if you're just going to use it to upset them sneakily. So, and speaking of sneaky, that gets us on to manipulative and controlling. And we have talked about them a fair bit. And we have whole episodes for mediating with a narcissist and mediation over manipulation, what to do if their goal isn't settling. But Mum, what do you think the number one thing a mediator would want anyone knowing if they've got a manipulative ex at mediation?
I think you need to stay in the room. Try not to cross paths with them. In other words, don't give that person any fun out of the process. Come early, leave later, or leave well before them, and don't give them anything out of this mediation. Don't let them see you upset. Don't let them see you get mad. Just keep it damped down. And then, of course, with manipulative and controlling people that you've been dealing with all your life or all your together life, you know how to handle that. To get anything across the line, you're going to have to let them have the kind of upper hand, and you're going to have to be fine with that. You know, I don't mean give substantial things away, but it might be that if their offer comes back to you and there's only a small amount in it that you would want really to have, like that they'll knock you down to think, then think about it.
I heard an example where they were pretty much property settlement, sorted, done, and at the last minute they didn't sign it, and they said, I'll only sign this if I get candlesticks. And that the candlesticks were bought for that person by their mother, and they knew it. So they thought, they're not going to agree to this because they're never going to give up their candlesticks that their mother bought them. And if their mum may have passed away, I can't remember. So it was like they deliberately did it to hurt them and also to look like they were doing the right thing. Like, I'm agreeing, I just want the candlesticks, without the other people really knowing how horrible and hurtful that is. But then I do know that she just went fine to have them.
Yes.
So they are going to try and do horrible things like that. They're going to really try and make themselves look good at the same time as manipulating the crap.
That's right. They're going to want to say, well, I made an offer and they didn't accept it. And that's what they want to say. I mean, there's many a slip between the cup and the lip, as Robbie Burns would say. It's an old poem. But it means there's still a few hoops to go through. If you reach an agreement with the manipulative and controlling person in mediation, they still may not put their name on it. On that, they might think, oh, well, that's taken all the fun out of that. If I agree, I want to keep taking this person to court. So, don't say that your mediation's failed. I think people need to listen to, if you've got a narcissist, is it mediation or manipulation? But always, a mediation is helpful. You get to know the other person's case a little bit. It's good practice for you. And you will have done your prep, so you've got it done now.
And write down somewhere for your extra homework for those people that have a coercive, controlling or manipulative, abusive ex. Write on the top of your piece of paper where you're doing all the homework we've given you, write that emotion is their fuel. And do not give them any fuel, because they are going to walk in there looking for, they're going to be rubbing their hands, go, oh, I can't wait to see her upset or him upset.
Yes.
I can't wait to get a rise out of them. I'm going to say this and it's going to really upset them, and they're going to walk out and it's going to be hilarious. Do not give them any fuel. Do not show them any emotion. And if you had no ability to hold back your emotion, if the only thing you can do is just stay in that room with the door shut, do that.
Do that.
But do not give them any emotion.
Yeah. I think that's really good. I think that's really good.
Well, we are wishing you guys the best of luck if you have got mediation coming up. We do have a really great run of mediation episodes. We've got an even better mediation mindset module where we help you go through all the documents and get everything prepped for mediation, including the disclosure and how to present it. If you're interested in that, you go to our website and maybe go to our webinar or let us know you're interested. But the other thing that you can do is go to our website and look at the podcast library. And in the podcast library, you can search a specific topic of what you are going through. Like you can go and search mediation. It'll bring up all the mediation episodes, or most recently-ish, the last 100. And you can go and listen to them all if you need that little bit of extra pep.
All the best, everyone.
Thanks, Mum. Thanks for your time, and wishing you guys all the best. Bye.
Bye, Laura. Bye, everyone.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.